Hello, Christy Arkovich from Tampa, Florida. We have a new announcement. I apologize for getting this out late. I've had COVID the past after the New Year's and so forth. It's put me a little bit behind. But last week, there was a really big announcement of the new IDR program that we were expecting, and it will be out sometime around July this summer, maybe a little bit afterwards. But essentially, the department, what they're doing is they're simplifying the income-driven plans. And I think this is fantastic because a big part of what we do is try to help folks determine which plan they should be on. There's a number of different income-driven plans, and they're very different from one another. It's not a one-size-fit-all kind of scenario. But one of the nice things that the department is doing, and when I say doing, is they're implementing this. It just started a 30-day comment period. This is what we expect to happen. This is what is requested, but it may change a little bit. If so, we'll put out a second guide as to what to do with some of the changes and so forth. But essentially, for the payment restart that's going to start in August, probably around August. I mean, that actually is subject to a little bit of change too, depending on what the Supreme Court is doing with the 10,000 forgiveness. But we expect the payment pause to probably end in early fall around August. And so before then, what are people supposed to do? The old repayment programs, IBR, ICR, even ISR is still out there. It's a terrible program. If you're on ISR, contact us immediately. You've got to get off that. But IBR for new borrowers, there's pay and repay. And so instead of creating yet another acronym and distinguishing between them, what they're doing is they're revising the repay program. Now, repay is something that came out in, I think it was 2015 or 16. It is something that the majority of borrowers would want to do. There are some reasons not to, but essentially the new program is going to eliminate one of the biggest reasons, and that is, what do you do if you're married, and what do you do if your spouse makes more money than you? For that, we usually would tell people, go on the older program. It's IBR, income-based repayment, came out in 2009. The numbers aren't quite as good. The payment's going to be higher, but you don't have to count your spouse's income, which may actually make your payment lower. And repay now is eliminating that. And so going forward, they're not counting, if you are married, filing a separate tax return, they're not counting your spouse's income, nor are they counting your spouse as a member of your household. So there's no double dipping, which is fine. I mean, I think that's a good move. It is something that is a backward step for repay, but allowing separate tax returns is humongous. We have a ton of clients who one spouse makes an incredible amount and the other one doesn't. And we would like to deal with that scenario in a good repayment program. So that's probably the most significant change for repay, is allowing a separate filed tax return to not have that income count. Major departure. The forgiveness is going to remain the same. So 20 years on undergrad loans and 25 for grad loans. That's going to remain unchanged. For those of you who are already on pay, you might want to consider staying on pay. It's 20 years for both, but there are some nuances of when you might want to get on or off one. Pay is going to be discontinued going forward. If you're already on it, you can stay on it, but if you're not on it, it probably will be eliminated after July when they try to get everyone on repay. Now, how is the payment going to be less? That's the significant question besides the married filing separately. Other folks have had a question on, well, how's the payment going to be less than what I already had on repay or IBR before? I'm not making any more money and I couldn't afford that payment. The deal is that the poverty level guidelines, if you recall, on an income-driven plan, your payment is not determined on your individualized expenses. So if you're taking care of a parent or child or have some medical expenses or just unusual expenses, they're just simply not counted. Regardless of how justifiable or needed they may be, they're simply not counted because it is an IRS standard that they look at. And the standard is the poverty level for your family size. So traditionally, repay has used a test where they allow you to count 150% of the poverty level for your family size expenses. And they're going to bump that up to 225%. That's significant. That's a 75% increase, which is half. So basically that change alone would result in a far less payment. Additionally, moreover, after they subtract, and what they're subtracting from is your adjusted gross income. So you look at your tax return. At the very bottom, it's going to have adjusted gross income. That's after some expenses are counted and such. Then they're going to subtract 150% of the poverty level for your family size from that number. And from what's left over, that's called discretionary earnings, discretionary income. Repay used to be 10%. 10% of that number, they would just basically take it, let's say it's $1,000, they would divide it by 12, and that would be your payment for the next 12 months. And that would be the income-driven payment. So what they're doing now is instead of 10% discretionary earnings for your payment, they're counting 5% for undergrad loans. It's still going to be 10 for grad loans. And if you have both, it'll be a weighted average. So if you have more undergrad, it'll be closer to 5. If you have more grad loans, it'll be closer to 10. But that's huge because there's a lot of folks out there with significant undergrad debt that will now be calculated on a 5% discretionary earnings payment. So that also will result in a far lower payment. There's some statistics that the Department of Ed has put out regarding if your income as a single person is around 30,000, your payment would be zero. If you're a family of 4, it could be up to 62,000 and change, and your payment would be zero. But those calculations alone, that's unchanged from what the earlier guidance was that we were given. And I do think that is going to result in a lot of folks who were previously basically left out of income-driven payment plans because of some crazy high expenses that they had. They're now going to be able to qualify, and they're going to be very excited about that low income payment with a forgiveness at the end of it. So the payment calculations changing incredibly. I mentioned about how pay is being shut down. The interest subsidy, that's something that we should cover real quick. The interest subsidy is a huge event that has caused a lot of people over the past decade or so to have a virtually unpayable student loan, because what's happened is they might have graduated with $30,000 to $50,000 to $70,000 of debt, but over the course of many forbearances and such, through either inability to get a job or some other pitfall has happened after graduation, they end up with a debt that's well over 6 figures, might be 100,000, 200, 300. The highest loans that we've ever seen have actually been $1 million, $1 million and 100,000. And that interest has caused many of these loans to be unpayable, unaffordable, unsustainable, and also has caused a very fearsome tax bomb at the end of the debt forgiveness. Because if you recall, income-driven plans, other than public service, have a potential tax liability at the end. Now, any tax debt, any student loan that is forgiven before the end of 2025 due to one of the stimulus bills will not be taxed. But many of these plans are going to have the forgiveness occur after the end of 2025, maybe 10 years down the road. And if that happens, that balance will be taxed as forgiveness of debt. Any debt that's forgiven over $600 is supposed to be taxed. Now, Congress could change that between now and then, but if they don't, that's a potential tax bomb. And it is one of the reasons why when we file a bankruptcy in an adversary process, we allege the enormous tax burden, the problems with our credits, our clients' credit scores and things, inability to buy a home, things like that, as part of their undue hardship. That tax debt is a problem. And so what REPAY is going to do is it's going to have 100% interest subsidy. So if your payment that you're paying is not enough to pay all the interest, then usually the interest would continue to accrue and the balance could get larger, ultimately to be forgiven and then possibly taxed. Well, now with the 100% interest subsidy, it will not continue to accrue. The payment won't get bigger. The principal would always remain the same if your payment was only enough to pay the interest. So you would still have that forgiveness of principal. If your payment is enough to pay some of the principal, then of course it would have a smaller balance each month and a lesser tax bomb at the end. But under no circumstances should it be larger. And that, I think, is significant because we have a lot of folks out there that we try to plan around that tax debt problem that they could have. So we're going to have the interest subsidy of 100%. Default and delinquencies. One other significant problem that many folks have is enrolling in an IDR program, and then continuing to recertify their income to stay in the income-driven plan. One of the nice things is that the department has recognized many of the problems that borrowers have had over the years. And one of those problems is an accidental default, or what I call a forced forbearance, which is basically where a servicer doesn't spend the time on the phone or whatnot in order to gather the income information, to put someone on an income-driven plan, to recognize which plan might be best for them, and also to explain how the plan works and what to expect. To avoid taking that time, they just put people on forbearances, or even worse, they just decline the income-driven plan. They send the 10-year standard payment notice to the borrower who can't afford it, who then defaults. And so for those of you who don't know, if you can't afford a payment and you're not on some kind of plan for a lesser payment, your loans will default at the end of a delinquency period. And so that period is 270 days, basically 9 months. You've got 9 months to figure things out. It is a lengthy time, but the penalties of default are huge if you accidentally default. And what they are is bad credit, which is a bit significant thing. You may not be able to buy a home because your defaulted federal loan will be caught by your underwriter on the CAVR system, and usually they would deny a home mortgage. You also have garnishment of wages with very little exemptions, if any, offsets of Social Security, and so forth. So to avoid unnecessary defaults or accidental defaults, what the department is doing is that if someone is behind 75 days, and this is under the new revised program, the new revised repay, if they're behind on a federal student loan after 75 days, they will automatically be enrolled in repay. And so they don't have to do all the hoops that a servicer may require or be in contact with a servicer at all. What you do need to do, though, is make sure that your IRS income information is allowed to be automatically generated by the Department of Ed's website. So on studentaid.gov, when you enroll in repay or anything, there's a way for you to link your IRS information to the student loan site. As long as that link is viable, so the department knows what your income is, they can automatically enroll someone in repay without needing any kind of documentation of income, pay stubs, tax returns, spouse's signature. They don't need any of that. All they would do is do the linking and automatically put someone in. So that 75-day delinquent to automatic enrollment in IDR, I think will be huge, because we do see a lot of folks who accidentally default and they don't really mean to. They know it's not wise, but they don't know how to avoid doing it. And then lastly, there are some folks who are already in default that they've already maybe consolidated a loan to direct. They've already rehabbed a loan recently, and so they're not allowed to cure that default any longer. I used to call those the 2 get out of jail cards. Now there actually is a third. The Fresh Start program allows for someone to remove a default due to the COVID situation. So that's sort of a temporary thing, but that is going to allow many folks to get out of default who previously were not able to. But even so, if you're not able to get out of default, that's okay, because under the new repay program, they will allow enrollments of a defaulted loan. Previously, no one could get IDR. If you had a defaulted loan, there was no way out, then you were subject to lifetime garnishment. There was no way to fix that scenario. We did occasionally try to, and we were successful in fixing it in a bankruptcy where someone would catch up the arrears in a plan, in a Chapter 13 plan, and at the conclusion, then they would be current on their student loan. But that was a very selective process. For one, you'd have to catch up on payments. Well, if you can't afford your payment, catching up is probably impossible. So it was a very rare circumstance. It also would possibly be expensive, especially if there was no other reason to file bankruptcy, if there's no other debt that someone could get rid of that would make bankruptcy make sense. So it wasn't a preferred mechanism by any means. But now it'll be automatic. So someone can enroll and repay even when they're in default. Now, I wouldn't recommend that, because your credit report will show the default. Why? Why not fix the default first and then enroll and repay? That way your credit remains in good standing the whole time. So there would be no reason why I would recommend that you do that on purpose. But if you're already in default and you can't get out, then sure, why not? Go ahead. This is perfect for you for that circumstance. Let's see. I just wrote a blog today, and I'm kind of referencing some of those points here. So that's why I'm looking at my computer every now and again. Um, the other last thing I think about the new repay program is they're going to allow a lot more deferments to count. There is a long list of them on the press release, I think. I won't state them all here, but many more deferments will count towards forgiveness than usual. So what is this revised repay? Just to kind of refresh you, is that it is a mechanism to avoid an easier repayment solution. All right, something that's a little bit more affordable and sustainable so that someone can ultimately obtain that forgiveness. It's likely to result in a tax-free forgiveness or a much less of a forgiveness than it would otherwise due to the interest subsidy. So we're talking about a smaller payment that's more sustainable, less of a taxable event at the end. And then finally, it's going to allow you to file a separate tax return. We have always been a proponent of being able to do that. You went to school, your spouse didn't go to school or didn't go to that school or get those loans. Why should he or she be liable? Not really not liable, but why should their income be used to have to pay your student loan and determine what your student loan payment is? So I think that question about whether or not someone can file a separate return is the biggest question that we had about the new program. And fortunately, it was answered in favor of borrowers. So I'm a huge fan. You should know that you have to have a direct loan in order to be eligible for repay. And so remember, for all those out there who still have the older FFEL loans, the Federal Family Education Loans, these are federal loans, but they're usually privately held and privately originated. You may call Navient and so forth. They may tell you it's a private loan, but it's really a federal loan that's privately held. Okay, so what that means is that the government has guaranteed that loan. It's federal, it's eligible for many of the programs, but it's not eligible for all of them. And one of them that a FFEL loan is not eligible for is repay. So if you still have a FFEL loan, it's very important for you to consider consolidation of that loan. And if you are going to do that, the deadline is May 1 in order to qualify for the IDR waiver. That is sort of a backdoor for those with public service as well. Anyone who is working public service and has had a FFEL loan all this time, as long as they would consolidate before May 1 to a direct loan, those loan payments that they may have made in the past towards a FFEL loan will count, including extended forbearances under that program, as long as they were working public service, correctly, full time and so forth for an entity that qualifies. Then that is sort of a backdoor into the public service waiver. That program stopped on October 31, but for most purposes, for 99% of the purposes, it continues to remain until May 1. The only detriment for folks who didn't meet the October 31 deadline is if you're no longer working public service. If you're still working public service, you're fine. Just make sure that you convert your loans before May 1 if they're the older FFEL loans. If you have direct loans, the IDR waiver is supposed to occur within this year. We're told mostly by the summer. We don't know if that's going to continue to remain to be true. We hope so. We hope that one-time account adjustment for anyone with prior loans that have been consolidated, FFEL loans, extended forbearances that haven't gotten the benefit towards counting towards any of the income-driven plans, all those things are intended to be fixed with the IDR waiver, the one-time account adjustment that should occur by this summer. So in order to qualify for this new revised repay program, you have to have a direct loan. You might as well do it before May 1, because that way you get the benefit of the one-time adjustment too. So I hope this has been helpful for you. If you still have questions about your federal or private student loans, you're more than welcome to set up a one-on-one consultation. We do charge for that. Our fee is quite reasonable, I believe, especially when you're considering the amount of debt that you're dealing with here. We'll go ahead and set that up, try to explain some of these programs, the interaction between them, what you can expect on your particular loans. We do ask that you pull your federal loans before the consultation. That way we'll know exactly what you have, so that our advice can be exact to your particular loans. And many folks have more than one loan. So you may have different answers based on the different types of loans or different dates of loans that you have. And there is some advantages to having old loans out there, because one of the attributes of the IDR waiver is that if you've been paying, even through extended forbearances, on an older loan, say in the late 1990s, early 2000s, there's a better than average chance you're going to be done with those loans, because the IDR waiver allows for a forgiveness to automatically occur at 20 or 25 years, regardless of what plan you've been in, if you qualify with payments, and payments include extended forbearances. So those old loans, a lot of them are going to be wiped out with the IDR waiver. So don't sit on your rights there. Don't let your FFEL loans, don't ignore them. We have a big fear that people will wait until the payment pause ends and a payment is required before they'll reach out. If you wait till August, that IDR waiver, it's done. It's done as of May 1. So make sure you don't wait. If you have any questions at all, please do a one-on-one consult with us. And I hope this has been helpful. Hope you have a wonderful day. And again, it's Kristy Yarkovich. Please subscribe before you go, if you will. That allows us to continue to offer this free service for folks out there with student loan debt and help you try to get that under control. Thank you very much. Have a great day.